Hey, this is Ken at Capital Advantage Tutoring, and my job is to kind of help people get through the FINRA licensing exams and just give general advice on as being a registered rep. So one of the places where people screw up is on the U4. Now, let me give a little background how I know how to fill this shit out. I worked on the stock exchange. I worked at a hedge fund first doing risk arbitrage, mergers, and takeovers. Then I worked on the stock exchange from about 91 or 92 till 2009. Long time on the floor, yelling, screaming, all that stuff, fun stuff. Then I switched to the dark side and moved over to compliance when the floor was kind of slowing down. And I did that. I was a chief compliance officer for like two or three different firms, one with 350 traders. So basically such high turnover that I was doing U4s with people literally every day. My assistant, Katie, was racking them up and we were going back and forth nonstop, always doing them at least one or two a day for 4 or 5 years. So I know how to fill this out and I'm going to help you. Now, also remember something. This will help you for if you're taking the Series 24 or one of the principal exams, maybe even the Series 7 or the SIE, so that you can understand when they say, oh, is this going to be on the U4 or disclosed? But this is mostly for new hires who are starting before they start that hell of a testing rain, whatever you want to call it. And I'm going to help you fill it out so that you're not sure about it. Some of the common questions people have, we're going to go over, and we're going to go through the U4 line by line. Well, almost line by line, because it's really freaking boring. Okay, so here's the beginning of it. I'm going to try to blow it up a little bit. So this is the printed form. You'll probably get one as electronic. So that's interesting, right? So you can get one to fill out. A lot of times you fill out an information pack that the firm has, and then they pre-fill some of it because those questions match a lot of the U4 stuff. But if they don't, what we can do is we can fill out most of it, and then we can fill out none of it and send it to you electronically. It's called allow rep to edit. So there's going to be spots where you can fill out, and the stuff you're not allowed to fill out will be grayed out. It makes it super easy. And all you have to do is you fill it out, you hit submit, and it doesn't submit it to the firm. It submits it back to the compliance department. So it's not like you're screwing up and you're sending it to FINRA. They're going to do it, double check everything, make sure it works, and then probably have you sign it before they submit it. E-signature works. Sometimes maybe I would sign it and then tell the person I signed it, and they would just go, okay. So this makes sense. General information. By the way, you'll probably not know the firm name. If they ask you to figure it out, just go on broker check and you can find it. If not, they'll give it to you. A lot of times, a lot of this stuff would be pre-filled out. Name, middle name, suffix. That's like second, third, fourth, junior, senior, blah, blah, blah. Okay, stuff like that. The fourth. Kenneth Finnen the fourth. No, there's never going to be another one. Okay. You may not, for the firm billing code, again, not your shit, unless they give it to you. Remember, some of the smaller firms have a packet. They give it to you, then tell you what to fill out. Other ones pre-fill it out for you. Or the third is they leave it fucking blank. Individual CRD, you don't know yours yet. If it's a first time U4, you won't have a CRD yet, so they'll have to submit it, and then you'll get one. Individual Social Security number, obviously what that is. Okay. Do you have an independent contractor? So remember that FINRA doesn't actually care what your relationship is. They have to know, but they don't care if you're working once a year and you're doing reps or you're full on W-2 9-to-5 employee. They don't care. 9-to-5, what a joke. So like I had got my other firm, we had 3 or 4 people that really they just had deals with people, and they would only do business like 2 or 3 times a year. Big deals. I mean, make a couple $100,000 on a deal. But they weren't working all day, every day, all day, for 250 days. They would work a few days a year and get paid on that. And FINRA doesn't care how you're regulated or registered, just that you are registered if you're acting as one. So even if you only work, once every 3 months and you're doing this, they want you to be registered. So they don't think of that as parking because you're actually performing a duty. Like they'd rather you do that than register, than deregister, than register. It's a pain in the ass. Just leave you registered. As long as we have what we think is a valid reason to have you registered, we're good. On that note, there's a thing called permissive registration. So if you have this and you have licenses and you work for a broker-dealer, FINRA actually is okay and promotes the fact that your firm carries all the licenses. It's called permissive registration. Even if you're not acting as a 24 or a 910, they let the firm carry it. So make sure your firm knows that, because some firms go, well, you're not acting in it, we're not holding it. There's no risk. It's called a permissive registration, and they're allowing you to have it just so that people don't park their licenses and have to retake the test again. Although that hurts me, but whatever. So they want to know if you're an independent contractor, if you're like a 1099 and you work just whenever you want, or you're a W-2 salaried employee. Now, again, there's a lot of this stuff here will be done by then, whether it's a registered or non-registered, the branch, the filling code, all that, located and supervised from. So if you have to fill this out, located is where you're, so the first thing is going to be located, where you're actually working out of. The next one is going to be where you're supervised from. So if there's an address where, like, say you have a branch in Norfolk, Connecticut, but the supervisory branch is in Darien. Well, located at is Norfolk, or Norwalk, whatever I said, and then the supervisor is from Darien. So supervisor is where your supervisor, where your branch is overlooking all your shit. If your place is a private residence, which is allowed, you can have a home office. If your location is a private residence, I can't speak, you have to check this off. And then again, they have multiple addresses here. They're not making it. So some people work out of more than one address, or some people work at a branch and at home. They want both filled out. And there could be more. So the actual online form, you can keep adding more and more branches. Okay, fingerprints. Okay, this one confuses some people. I was shouldn't. 99% of people are going to check the first one. 99% of people are going to be checking this one. Okay? That says I represent that I am submitting, have submitted, or promptly will submit an appropriate SRO fingerprint card. In reality, it's usually done online now, like NASDAQ or FINRA negotiated a deal with Sterling Identity Services, whatever. You can get it through, you set up an account with Sterling. They get the fingerprints. It's all done electronically. You're going to go to like a back of a UPS store or something like that and get fingerprinted. You have to do it promptly. The second one is that more like if you're doing an amendment. By selecting this option, I represent that I've been employed continuously by this firm since the last submission of fingerprint cards, meaning I got a fingerprint card 20 years ago or 10 years ago. I have been continuously employed by them, so I do not need a new fingerprint card. Okay. Now, the third one, again, it could be a few people. If you worked at this firm under a different SRO, like let's say your firm is a member of FINRA and the NFA, futures, okay? And you got fingerprinted through the NFA stuff, but not FINRA. Now you want to add on the FINRA part. You're going to say, hey, listen, I've already been fingerprinted with the NFA. I'll have them send you, or I'll send you the results from that fingerprinting. Hopefully you get nothing out of it, because they do your criminal background check. Remember, it's going to the FBI. So I've seen stuff where it's like, well, that was supposed to be expunged, and somehow it shows up. So the FBI has all the records. Okay, that's the first three. All of them, you're getting fingerprinted. It's just whether you had been fingerprinted at all. The next two, well, the next one is exception to the requirement. That's probably none of you. This is what I tell everyone. You know, if you would know already if you were exempt, you would need to watch this video and know. So if you're exempt or have an exception to the fingerprint requirement, it's because of something under these two acts, and you already know. So don't worry about it. If you don't think that's you, then it's definitely not you. The last one is if you were only going to be an IAR only, not for broker-dealer, literally IAR for an investment advisor. This way, you're going to check off whether you're only applying in jurisdictions where they don't have fingerprints. Because remember, IAR registers at the state level. So each state has their own rules. Like Texas doesn't have fingerprints. Maybe Florida does. Maybe New York does. Maybe Pennsylvania doesn't. I don't know the rules. But the point is, if you're only going to states where there's no fingerprint requirement, you can check the first box. If you're submitting to jurisdictions where they may have it, you're going to check the second box. And again, you're going to check off here saying I'm an IAR only. If you are getting the 66, this is not for you. This is like literally the only exam you take is the Series 65. Next is registration with unaffiliated firms. Now, this is almost, again, none of you. So this is like if you work for JP Morgan and Goldman at the same time, that's almost literally impossible, okay? There are situations where it could happen, but for the most part, this is not a thing. So 99% of you will say no. That means your registration, you're going to be registered with two broker-dealers that are unaffiliated. Affiliated is fine. Unaffiliated means you're not under common control, and that's called a dual registration, and pretty much nobody gets that. It can happen. Like I had to do it in the early 90s because someone needed help running. I was on the floor, and I was at one firm, and somebody else on the floor needed someone with a Series 7 and knew what I was doing. So I actually worked for those two firms for a very short time. It was a lot of hoops we had to run through. Okay. And you know what I get paid for that? I got fucking paid lunch for that. I didn't even get paid a salary. The guy was so fucking cheap. Les Silverman. Anyway, if he's dead, RIP. But God damn it, you could have paid me something for that instead of just fucking lunch every day. And it wasn't a good lunch. Okay, on to the next. 40-year-old rant from 1991. Okay. Now, again, I say that again a lot. It's going to be, for the most part, this is going to be done by the firm. Because you don't know what the SROs you are. It's always going to be FINRA. It's either grayed out one, so that certain licenses only register with certain places. So I'm going to go through the top ones. Series 6, top off, right? That's literally just, you're only selling mutual funds and annuities. You're at a limited broker-dealer. Only FINRA honors that. None. Now we have the Series 7, which you can sell everything. That could be on anyone. And again, you're not going to fill this out. You don't know what they're doing unless they say, oh, check off FINRA, New York Stock Exchange, Philadelphia. They're going to tell you that you do not have to make these decisions. I'm just helping you out. The other one is the DPP only rep. That's Series 22. A Muni Securities rep. That's a 52. Securities trader, that's like equity trader. That's a 57. The 79 is you're just being an investment banker. And again, a lot of these are just FINRA. If you want to just do private securities like Reg D and stuff like that, that's 82. I have a lot of people coming in with those, but it's so hard to find material for that. The 82, the 22, and the 52 is okay, but the 82 and the 22 are almost nearly impossible to find materials for. So if you want to be a research analyst, you're going to do 86, 87. Operations is 99, stuff like that. Those are all you may have to check them off. The firm will tell you, but most of you will get the 7 or the 6. Some will get the other ones. Remember, this is also irrespective of having the SAE. These are gone. I guess if you could have them, if you already have the licenses, you can check them off, but they're all gone. Now, if you're going to be a principal, it's the Series 4, which is for the registered options principal. If you're a general sales supervisor, the 910. Now, remember, the 9 and 10 kind of go together. They're different exams, but they're kind of useless if you don't have both. Okay, compliance officer, Series 14. That's exam I took a long, long time ago. Okay. Then we have other ones. The GS, the general securities principal, research principal, they're all the 24. But what happens is if you only have like the 57, you would check off TP, this one, trading principal. You still have the 24, but it's only going to be working for that stuff. Okay. All of these are principals. You have the FinOp. That's for if they want to be the financial and operations principal, literally like the CFO, not the CFO, but like a CFO. All these are different licenses. You'll know if you have them or not. You don't have to worry about deciding. Okay. Then here's the category you're going to be, whether you're an approved person, compliance office specialist. So sometimes you don't need a license for this. Whether you're going to work on the floor, that was me for a while. If you're going to do margin, LE and LS are for margin. If you're a member of the exchange, again, all these things are just what your category is. And they check them off. Your firm is going to tell you what to do. That's why I'm going through it quickly. Here are the states you're going to be in. Your firm will check off what states you're in, where you have a business, where you have either on the broker agent side, where you have one client, or on the IAR side, more than 5, or a place of business. They'll check them off. Your firm will probably tell you what states. For the most part, you'll start off just checking off the state you're in. And then after you pass your 65, 66, or 63 exam, they'll check off what they need to. If you check all this off and it gets submitted, that automatically opens up a window right away for your exam. So sometimes people don't want to do this right away because once you check it off, if you don't have the license, it's going to open it up. And that's what these things do, right? So if you check off one of these things and submit it and you don't have the license up here and you don't have a license, it automatically opens your window. So you want to make sure that before you check that shit, you're kind of ready to take the test. I mean, you have 4 months, but who wants that pressure? Okay, now, affiliated firms. This is like if you're working at a broker-dealer that is affiliated with your firm under common control. Like I worked for G2 and Beacon Gate at the same time. They were owned by the same LLC, the same people, so it was considered an affiliated firm. I didn't want to work for both, but they kind of made me because I was the only one who knew the compliance stuff. Okay. I don't like working for multiple firms. It just causes problems. So if you're going to work with another firm, you check off yes. Then you name a firm, the CRD, which again, probably will be mostly told to you. Are you a W-2 employee? Are you a contractor? If you're a contractor, check it off. If there's a billing code, stuff like that. Again, it looks very similar. Where you're actually located versus where you're supervised from. Remember that. If both of these things, it's where you're located, where your actual office is, and then another one is where you're going to be supervised from. They both could be the same place. Remember that. Or if you have a private residence, all these things. And again, you can, I'm going to say the word again a million times because there's a lot of duplicity in here. If that's even a word. I'm going to say that again because it shows up so much. If you're an affiliated firm, do you need a fingerprint? This is where you might have to come up with a new fingerprint. Most of you are going to check off this. Now, some of you are doing this, could be this one, the second one, which says, I've been with the affiliated firm continuously, and I've already got fingerprinted, I've never been not at work. Same thing. I'm not required because the fingerprint submitted by the filing firm still applies. Again, I'm with the filing firm or the affiliate if I've worked for them consistently and I have a fingerprint on file. I do not have to do it again. These are all the same things. Look, the exceptions, not you guys. And then if you're only an IAR, works. Nothing changes. Now, these are examination requests. So if you didn't check up there, and if you already have one filled out, you want to open up a window, which is a 4-month window for your exam, you scroll right down here, you check it off. When you hit submit, boom, it goes right to FINRA. They open your window the next day. Now, if you have any of these, the CFP, the CFA, the CHFC, the CIC, or the personal financial specialist designations, those are special certifications. You have to be licensed. You have to get courses for, pass an exam, and get certified. If you have them, boom, you put them in here. It shows up on your CRD. Now, here's identifying your name, again, middle name, suffix. Now, remember something. I should have said this before, but I'm going to say it. I'm not going to say it again because I didn't say it before. You have to make sure it matches your driver's license or whatever ID you're using. Because if you go to take a test and the name you put in is differently actually looking than your license or your ID, they're not going to accept you. They're going to send you home. Now, I'm going to say this. A lot of my Spanish students, their names are either the suffixes before this or their names are in a different order. You have to make sure it matches. One of my students had that. She works with JP, and she showed up, and they go, well, the names are the same, but the two middle ones are flipped. And they wouldn't let her in, which is crazy, but I get it. So she went back. It took her about a week to get JP Morgan to fix it, and then it was done. Okay. Your date of birth, the state or province you're born, country, male, female, height, weight. Don't lie. I mean, you don't have to. You don't weigh yourself and then do it. Just be ballpark it. Hair color and eyes. Me is easy. Gray hair, hazel eyes. Okay. Hazel eyes. Okay. If you have any other names that you're known by, nickname, aliases like, Pete the Eye or Pete the, Pete the Gimp or something like that. Any nickname in here you want to put in here. Okay. Okay, scrolling on down. Okay, now, these are all things that'll show up on this year 24. It's more than 24. You have to show your past 5 years residency, okay? Give all the addresses. Start with the current. So you start, your most current is here, and then you work your way backwards, okay? Start up here with your current and work your way backwards. So where you're living now is here. I will say this again. This is where you start with your current address and work your way backwards. They want 5 years. Don't do 10 years, do 5 years. It's going to be with the month and year, not the date. Month and year you started, month and year you finished. And this would probably say current. You would put current here. And then you'd have to update them on your U4 and they'd figure it out. Remember, any kind of changes you want to update within 30 days, baby. Okay, remember, 5 years residence, not 10-year, 5-year. Now, your employment history, you have to show the past 10 years. You cannot, they say you have to count for all time included. Meaning, if you're in college, you put it in there. If you're traveling, everything has to be accounted for. You can't have more than 3 months without it being accounted for. Well, I was 20 when I started, right? So I had to go back to the time I was 10 years old. They literally put Solbrook High School, Solbrook Middle School on there. It's crazy. And I put in there from, 1979 to 1980, whatever. So you put in full-time student, you name the schools, okay? Look, you don't have to, if you had two part-time jobs and you're 14 and one was delivering papers, you don't have to put it there. Unless it was on your resume, then you probably should. But basically, they want to know where you were the whole time. So if you're a full-time student and you had odd jobs, I don't think they're going to care that you missed, I was in charge of the student center for 2 months. They don't care. You do have to name from when you started to when you end and ballpark it. I mean, if you say May 94 and it was June 1994, they're not going to kill you. It's not that big a deal. Just make sure that all all employment is back 10 years, and you cover it. You just have to make sure that you're covered, and it's not more than 3 years without some sort of coverage. If you're in the service, right, military service, if you're homemaking, and look, if you're unemployed, you're right, unemployed. If you're traveling around the country doing Instagram and TikTok posts, put travel, okay? You can do that. Just cover the months you did it. If you're out of work for 3 months, unemployed, you got to do that. 10 years, remember. And you have to check off whether it's investment related or not. So most of your jobs won't be, if you're young, none of these will be true, but you may have worked for an investor. You may have done an internship 3 years ago. Boom, if that's your firm, boom, name of the position, where you work. They want the name of the firm, the city, the state, and the country. I don't think they need the exact address because half the people don't have it. They just want to know the name of the firm and the city, the state, and country. If you have an outside business, okay? If you have an outside business, like I've always had a second job. When I first started working, even on the hedge fund, I always valet parked and I did other stuff like that. I drove a bus for a little bit, okay? I did all these different things, always to make money. I'm always kind of hustling. I don't know what it's like not to have a second job. So I've always had to disclose that every time. I go, valet parking, and then since 2005, I've had to put in tutoring, right? And I put in like what I'm doing it for, what my position is. Is it a conflict? Is it investment related? Do I do it during how many hours a week? 30 hours a week during business hours? Yes or no? Stuff like that. You have to have a little description of it. Okay. You have to put the name of the businesses, whether it's investment related or not, the address, what it does, your position, title, or relationship, the start date, and about how many how many hours per month you do it, and are they during business hours? And tell them what you do. And it can look, and again, it's a lot. I mean, what they do is they'll just say, if I remember at the electronic one, you just hit enter and it gets longer and longer and longer. It says, add another business. It goes down. Just type it in. Okay. Now the disclosures part with, again, most of you will have none. So if you do, you just check down to none. But you got to know this stuff. You got to read them and know, because if you don't check something that you should have, and you've by mistake, they're not going to be okay with that. So here, start with the first one, 14A. Have you never, right? Have you ever, not in the last 10 years, have you ever been convicted or pled guilty or nolo contendere in a domestic, foreign, or military court to any felony? Any felony. Listen to me. Any felony. It doesn't matter if it's securities related or not. Felony is felony. Have you ever been convicted? A, yes or no. B, charged. Remember, charged doesn't get you statutory disqualified, but if you've been charged with a felony, officially charged, like technically if you're arrested and then they let you go, but they don't charge you, that's not a charge. It means indicted, arraigned, formally charged. Not just, hey, the cop, you're being under arrest for doing this, and then they drop it. That's not the same. But again, and charged with any felony or been convicted or pled guilty. Okay. 14A2. Has any organization that you controlled been convicted, pled guilty, nolo contendere to any felony, or B, charged with any felony? So again, the first one is, have you ever? Never have I ever. And two, has the firm you controlled ever had that happen? Like if you worked for HSB as a regular employee and they did that whole, they complied with felony, you didn't control it. Don't worry about it. It's not on you. But the CEO did. Okay. 14B. Have you ever been convicted or pled guilty to or nolo contendere? I'm just going to say convicted or pled guilty, and nolo contendere is fun, but whatever. To an investment-related business, okay, or to involving investments or an investment-related business or any. Now, it's not just securities related. Listen to me. It's fraud, false statements like fake IDs, omissions, lying, wrongful taking of property, that's like stealing, burglary, bribery, perjury, that's lying, forgery, making up a fake ID again, counterfeiting. Catch me if you can. Extortion or conspiracy to commit any of these others. So it's not just like, did you commit a misdemeanor of securities? It is a misdemeanor under this. And again, under investments and investment related, or fraud, false statements, omissions, wrongful taking of properties like stealing, bribery, perjury, forgery, counterfeiting, extortion, or conspiracy. That's been convicted of it. 14B1B is have been charged with it. So 1A is convicted, 2B is charged. Remember, again, officially charged, not arrested for it, but charged. There's a difference. Again, the second part of it stands as the first one. Has any firm you had control over, same thing. convicted, pled guilty of all these things. Or, again, B, it's the same thing, been charged with the misdemeanor involving all of these things. That's the way it goes. It's basically the questions so far are, have you been convicted or been charged with it? Has a firm you're in control over been convicted or charged with it? That's a pattern. Most of you will say no. Remember, checking off yes doesn't automatically kick you out of the business, but convicted of a felony in the last 10 years would. Convicted of one of these misdemeanors would. Now, remember something. This is not the same as like getting a bar fight or a misdemeanor DUI. I mean, they're important, but you don't have to disclose them, okay? A bar fight, other misdemeanors other than this list, you don't have to disclose unless your firm asks for it. Now, for regulatory actions, has the SEC or the CFTC, which are federal regulators, have they found, remember, found you means kind of guilty. Have they found you to make a false omission or statement? Have they found you to be a violation of its regulation or statutes? Have they found you to be a cause of a business having its authorization to do business denied, suspended, revoked it? So basically, if you work at a firm that had its licenses suspended for trading, if you didn't cause it, then you say no to this. Have an order that's a judge's order been entered against you with investment-related stuff? Again, this is not the same as you having a dispute with your neighbor over the fucking fence being 3 feet too far. This is investment-related. Has the SEC or CFTC imposed a civil monetary penalty or a cease and desist from any activity? This is, again, not your neighbor, not the local judge. This is the SEC or CFTC. Okay. 6, have they found you to willfully means on purpose, violated any of the federal acts? I'm not going to fucking read them all, okay? Okay, now, 7, how have you found to willfully aided, abetted, and counseled, commanded, induced? That means, have you got someone else somehow, by crook or by rook, to violate one of these rules? And the last one is, have you failed to reasonably supervise someone who's up to your supervision with these acts? Fail to supervise is usually that your supervisor, you have certain checks and things you have to do all the time. If you don't do them, you can be found in this, okay? And again, a lot of times, if you make a mistake, they won't give this to you because this is a big deal, okay? Failure to supervise is that if you fail to supervise what was going on and you known or should have known. So if you knew about it and let it go, that's a problem. Or should have known, which means if you had read the 5%er emails or brought in the mail or did the due diligence that you're supposed to, and you would have found it then you can be in trouble. So it's either known or should have known. Should have known is if you had done your due diligence, you would have found it. If you do your due diligence and you do everything you're supposed to and above and beyond, and they still get away with it, then you won't be nailed with failure to supervise. You have to make reasonable efforts. You don't have to be perfect. Okay. Now, has any federal regulatory agency or any state regulator, so that's the state or foreign, so that's like any state regulator, that's probably some other federal regulator, like Ginnie Mae or FDIC or something like that, or foreign financial regulatory, or that's a foreign regulator, like, the London, the Toronto Securities Commission, or the London Securities Commission, or the Brazil one. I know London's not a state, but whatever, okay. Again, have they found you to make a false statement or omission? Basically been dishonest, unfair, or unethical. Found you, which means that not charged, found guilty. Found you to be in a violation of an investment-related regulation or statute. Have you found to the cause of an investment-related business having a license expired? Have you had a judge or any kind of regulatory issue an order against you to stop you from doing an investment-related activity? Have you ever been denied, suspended, revoked, or licensed otherwise, but prevented you from associating with investment-related business or restricted your activities? You would know this. Most of you know. That's like if the state goes, you're banned from doing business for 3 months. That's suspended. Denied, suspend, revoke. If you're taking the 63, you know what the hell I'm talking about. The second part of this, have you ever been subject to a final order by them that says you have done this stuff? So let's do it. So have you ever been subject to a final order by a banking commission or savings and loan or credit or national credit unions or like the federal banking agencies, like the Federal Reserve? Have they subject to final order barring you from association with the entity? Okay. Or basically have your final order based on violations of laws, meaning you can't do business. Like literally, if you're picking yes to either of these, you're not working in the business because they basically barred you from being in the business. Checking off these would say you can't work. I'm not saying not to do it, but if you did do it, you can't work here. They'll find out anyway. Again, it's a lot of the same questions, but they ask under different names. Has any SRO, that's like FINRA, that's NFA, CBOE, found you to make false statement of mission? They really hate the lying. Okay. Found you've been involved in a violation of rules other than a minor rule violation. Okay. Minor rule violations are little things that, that are small. Like I think it's under $2,500 fine. It's just like a little ticky-tack violation. Don't do those. It's real violations. Found you've been a cause of an investment-related business, losing its license, denied, suspended, revoked, or restricted. Same questions. Have you been disciplined? Okay. Have you been expelled or suspended by the SRO? Have they found you to willfully violate any of the federal securities acts? Have they found you to willfully procured, induced, counseled someone else to violate the rules? And have they found you to failure to supervise? Those last three, found you to willfully violated, found to induce others, or failed to supervise, are literally at every check thing. And again, most of you would say no. As a contractor or an accountant or an attorney, has your license ever been revoked or suspended? That's a yes or no. Have you been notified in writing that you're now the subject of any regulatory complaint that can result in an answer to the 14s that we just did? So listen to me. So this is what they do. Have you ever, right? Yes or no. And then are you now under investigation for those things? And by the way, anything you answer yes to, you will be automatically forwarded to the DRP page where you need to explain that shit. And that's all going to show up on your broker check, okay? So any kind of yes answer to these things. So you have to answer honestly, but it sucks if they do. If you are committed or violated or found, or you're currently under investigation for one of these things in the 14B through E kind of thing, then you have to answer yes, even if you have not been found or convicted. Has any domestic or foreign court enjoined you? Enjoin means it's an injunction. It's literally a ban from doing something. So if the court enjoined you from doing investment-related activity, has a court, domestic or foreign court, ever found you a violation of investment-related activity? Has a domestic or foreign court dismissed? Now, remember, if you sign a settlement agreement to dismiss charges, this you have to disclose. If they drop the charges on their own, that's one thing. But if they dismiss investment-related civil action brought to you by state or foreign regulatory body, if they dismiss it due to a settlement, you have to disclose it. Again, then they get you. Are you named in any pending civil action that can result in a yes to any of these things? Okay. So again, the bottom line for this stuff is: have you ever been charged? Have you ever started a firm that's been charged? And then all these things, felonies, misdemeanors, stuff like that, or convicted. And this one says, are you even under investigation for that? Because technically, we can fill this out now, and then the pending investigation gets concluded in a month. As long as I knew about some sort of investigation about me for this stuff, I have to disclose it. Have you ever been named as a respondent or defendant in investment-related consumer-initiated arbitration that alleges you're involved in sales practice violations? That's like churning and front-running and shit like that, okay? Is it still pending? Boom, check one. Resulted in an arbitration award? It doesn't matter how much, yes or no, could be $1. Was settled prior to 2009 for $10,000 or more. Was settled after 2009 for $15,000 or more. They keep changing those numbers. More disclosures. So I want to show you the difference here. Have you ever been named as a respondent or defendant, or been the subject of? Named is you're just one of the named people. Subject is you're the fucking reason. Okay. So again, a subject of that was settled for $10,000 or more before 2009, or $15,000 or more, or after 2009. Within the past 2 years, have you been the subject of an investment-related consumer-initiated written complaint not otherwise reported under 14 I2C, blah, 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 that you allege you're involved in sales practices of more than $5,000, or that you're involved in forgery, theft, misappropriation, conversion? So conversion of funds is when you take some of your client money and throw it in your own bank account somehow. And if you read these quarterly reports, it happens way more than you freaking think it is. Okay, now, in the last 2 years, 24 months, have you been subject to an investor-related complaint by a consumer that alleges that you are sales practice violations, or that you're involved in forgery, theft, misappropriation, or conversion of funds or securities? That's that one. Now, if you have an arbitration claim or civil litigation after May 18th, 2009, you do 4 and 5. If you don't have that, you don't worry about it. Have you ever been the subject of an investor-related, consumer-initiated arbitration claim or civil litigation which alleges that you're involved in one or more sales practices which was settled for 15 grand or more or resulted in arbitration or civil judgment for any amount? So remember, so if it's settled for more than 15 grand, you have to disclose it. If it's an arbitration of any amount, you have to disclose it. Within the past 24 months, have you been the subject of an investor-related, consumer-initiated? Remember, consumer-initiated means that the customer said it started it, okay? Arbitration or claim or civil litigation not reported before that allege you're involved in sales practice violations of $5,000 or more, or that you're involved in forgery, theft, misappropriation, or conversion of funds or securities. Again, yeses will all. Anytime you answer yes to this, you're automatically going down to the page we're going to show you later where you fill this shit out, okay? Have you ever voluntarily resigned, been discharged, or permitted to resign after allegations are made of violating investment-related statutes, fraud or wrongful taking of property, or failure to supervise? So sometimes firms will let you resign during an investigation to stop it. And if you do that, you have to disclose it. FINRA figure this shit out. Okay. Now, within the past, this is the one that more people answer this. Not as many, but still more. Within the last 10 years, have you made a compromise with creditors, filed bankruptcy, or been the subject of an involuntary bankruptcy petition? 2, based on events that occurred while you exercise control over it, has a firm filed bankruptcy, compromised with creditors, filed a bankruptcy petition, or subject to an involuntary bankruptcy petition. So again, 1 is, have you ever done this? And 2, has a firm that you controlled, not a firm you worked for, firm that you controlled did it, okay? The third one is, if you is a broker-dealer that you had control over committing sales practice violations and stuff like that, okay? Has a bonding company ever denied, paid out on, or revoked a bond for you? So when you start work, you have to be bondable, which means there's a company that's willing to bond you that for a fidelity bond and stuff like that, that covers fraud and stuff like that. If they say no, if they say they won't do it, then that's going to be a problem. That means you have some sort of credit problems where they don't trust you. And the bar is fucking low for them to trust you. So if they don't trust you, there's something wrong. 14M, did you have any unsatisfied judgments or liens against you in the last 10 years? So if you had a judgment or lien from you from 20 years ago, okay, and then you paid it off more than 10 years before you registered, you don't have to disclose it. Easy stuff. Now it's just a signature stuff. You're going to sign this, put your date, and then they're going to sign it. Now let's go into the rest of it. So now what happens is, if you are registered, so this is where they try to trick you a little bit. If you've been registered within the past 30 days already, and then you switch firms, you'll get a temporary registration while they're figuring this shit out. Because the idea is, you've already been registered, there isn't a problem, so they're going to give you a temporary registration for up to 30 days. As long as you've been registered with another firm within 30 days of you filling out the application. Scroll on. Some of these are not, this is the firm signatures, not yours. You don't care. Okay, here we go. Remember I said sometimes they give you extra sheets to do. Here are the extra sheets to fill out all the stuff that you couldn't do before. Now, if you have a bankruptcy or compromise those creditors, you figure it out, whether it's 14K2, whether it's the firm you worked for, whatever. Then you check off bankruptcy, compromise, declaration of bankruptcy, liquidation, receivership. You'll know these, because if you have a bankruptcy or any of these things, you'll know the terms you're talking about. Okay. When it happened. Okay. And if you don't have an exact date, explain why. I can't fucking remember. Okay. Or maybe it was pending over 2-3 months. If this was for a firm you controlled, they want the name of the firm, your position title, as an investment related. Okay. If it was a court action brought in federal, state, foreign, other, name of the court, location of the court, the docket or case number they want. Okay. Is the action, if it's pending, you can check yes. Okay. Then you're going to fill out as much as you can. If it's not pending, basically they're saying, what happened? Who'd you pay? What was the ending? What date did it end? Exact or explanation. If a compromise with the creditor, name of the creditor, how much you originally owed, and then you want the terms and conditions. So a SIPA trustee is for SIPC. So if you're a broker dealer that declares bankruptcy, they're going to appoint a trustee to help you out. So they're going to say how much you got, name of the trustee, all that stuff. You'll know that information. If you do bankruptcy, there's a more, you may use this field to provide a brief summary of the circumstances, because this shit is going to show up on your U4. Disclosures. If you have a disclosure, any of the yes, look. If you've been so this is 14L. This is for if you're denied a bond. So instead of the name of your policy holder, like the firm name, the bonding company that said no, what, were they denied, were you paid out, revoked, when it happened, did you get a payout, stuff like that. Any kind of extra comments, you can always add comments here, and any kind of disclosure, I would always put some sort of mitigating disclosures. You want some context. Okay, here we go. So these are, if you have a disclosure under for any of these things, if a court action, you have to say what agency, what happened, whether it's a cease and desist, all this stuff. Okay, you're going to know, and again, you'll know all these things. Based on the filing date, if you're served, remember, because now the 14B, a 30, and you have to understand, no matter what you do on this, FINRA is going to come back and want more information. I don't care if you basically put the perfect summary written by Ralph Waldo Emerson, it's going to come back and say we need more information. It's just what they do. So if you just be ready for that. So expect if you have a disclosure like this, it's going to take an extra week or two. Filing date in the action. Now remember, if you go to court, they have to serve you notice that you've gone to court. So that's what this is. Date notice process was served. That's where they go, hey, is your name Ken Finnen? Yes, well, you've been served. That's what they're talking about here. Okay, if this happened, if the court, what was the product that they used? They want to know. You have to disclose this shit. Now, if it's formal action, where that's formal action, officially charged, convicted, stuff like that, who you worked for at the time, and then describe the allegations. And again, look at your information must fit within the space provided. They're dicks, okay? Is it now pending on appeal or is it final? So if it's final, you just check final. If you're still appealing it here, if it's pending, they haven't done anything, boom, okay. If it's pending or limitations or restrictions, fill in the details here. If it's on appeal, they want to know everything: the name of the court, the location, the docket number, the date appeal filed. If they don't have the exact date, why? Okay, the details, what's standing on. If there's any restrictions, provide details. Okay, and you're going to do this for every single DRP. So if you have a bunch of DRPs, you have to fill out for every single one. Okay, now how is it resolved? Was it vacated, withdrawn? Did you consent to be? Did they? I guess they got rid of it. Judgment rendered, vacated. I don't know what the hell that means, but you'll know. It's vacated means it's kicked out of court, settled or dismissed. Okay. Again, resolution date exact or tell them why. Was there a sanction? Was it civil administrative penalty, cease and desist, disgorgement, injunction, monetary penalty, restitution, pay the customer back, stuff like that. Okay. If you're suspended, how long? If it's so, here's a registration capacity affected. So it's like if you're suspended, how long, when it started, when it ended, and if it's exact or an explanation. More stuff. Again, this isn't more. It's if another registration was done, fill it out. How long, when it started, when it ended. Again, how long, when it started, when it ended. Any kind of monetary. How much is it? Maybe it's the firm you did, right? So if the firm is amount, how much you owe, stuff like that. How much you paid, if you don't know when, why. Was any of the portion of the penalty waived? And that happens. Sometimes FINRA will charge a penalty and realize that the person doesn't have enough money to pay for it, so they'll waive the penalty. Same question. Because they know when you get one, it's more than one. Same questions. Is it monetary fine, disgorgement? Disgorgement means giving the money back to the customer. Okay. Restitution is paying the customer back. Like kind of the same thing. Total amount, portion, how much, the total amount for the firm or you, how much is your portion, date. Same thing, how much, your portion, date. And you can always put comments in front of these things. Again, in the TRP, so if you have any kind of these criminal complaints or anything, 14A through B, we went through these already, you can scroll back if you want. This is convicted or pled guilty. It's all criminal stuff, okay? That's what they're talking about, the criminal, all that stuff. Criminal DRP. I should have just looked. It said it right there. Okay, so now this one, the criminal DRP. This is the 14A, B, or have you ever been convicted or charged, all that shit. So basically, if it was brought against your firm, name of the firm, whether it's investment-related, position, or title. Where was it done? Was it in federal, state, foreign, military, whatever? Is it now pending on appeal or final? Whatever it is, put it in here. Date first charge, stuff like that. Formal charge, number of counts, how many counts? Like Bernie Madoff had like 182 counts. It's 182. Now, what happened? So, and the name for and the plea, how you pleaded, whether it's a felony or misdemeanor, and all these things, acquitted, amended, they change it, convicted, deferred adjudication. A lot of times what they do there is that if you're screwed up, but it's the first time, they'll give you a chance to fix your shit and then maybe expunge it after 5-10 years. Dismissed, not found, not guilty, all these things. Pre-trial intervention, that's where they get ahead of the court. They go, let's try to figure this out and get you cleaned up. Okay. If it's reduced, all that stuff. But it's all going to be disclosed here. If it was amended, boom, you fill it out here, and then you say how it's ended. And these are all for more. Basically, you have to fill this out for each charge. So if you're charged 142 times, it's going to be in here 142 times. If that happened, I would just quit. Same thing over and over and over again, because I know people fill out a lot of shit. And again, even to this, you can always put comments in there. This is the part for arbitration, customer complaint, civil litigation. The customer name, where the customer lived, where you employed, what they said, the allegations, and then here, what product was it? Alleged damage, how much they say. Is it an oral complaint, written complaint, arbitration form number, the docket case? This is all boring shit, but you just need all this information. Hopefully, if you enter note everything, you will not ever have to see this shit, okay? Is a complaint done by the CFTC, okay? Is the arbitration CFTC or civil litigation still pending? Well, a lot of times if that's a yes, they might send you. They may say, come back when you're done. If it's not pending, is it closed, withdrawn, denied, settled, arbitration award, evolved into arbitration? Boom, okay. And only if you're a named party. The guy to work on the okay, so I was on a arbitration with the guy Martin Shkreli. I think he's in jail now, but he's such an asshole. But I was part of it because I was part of RBC, and I was a compliance team, and I had to sit in on that arbitration. It's great. But again, if it's not pending, award money. What happened evolved into civil litigation like court. Okay. So here's the thing. So if you're not a named party, so if the status is arbitration, reparation, where they're trying to help people out. Reparation means give the money back. And you're not a named party, you do 7C and you put it up here. You click off C. You just if the information in, and then you're done. If you are a named party, you have to do all the rest of the stuff. As of basically, if it's complete, what date did it become final? If there's a dollar amount, how much you're on the hook for, basically the who was filed with, whether it's FINRA, whatever it is, the docket case, and again, the process. Again, they want so much information. I say the word again a million times. The date the service was, the process was served, meaning the notification saying, you can Finnen, yes, well, you've been served. Is it still pending? Yes. If it's not pending, what the fuck happened? Again, more and more stuff. If the matter is a civil litigation, you got to fill out, if you're named, hopefully you will not have to do any of this stuff. Where the court was filed, it's all the same stuff over and over again. What court it is, name of court, docket number, location of the court. If it's not pending, what happened? If it's pending, you got to check off that it's pending, and then you don't have to fill this out because you don't know. When did it end? So I know I'm going quick through these things, but it's the same thing every time. What did you pay? How much is the firm going to charge? How much you pay? Where was it done? What's the docket? It's the same thing every time. Where was the court? What was in the court? What was the docket? You want to make comments? Always make comments. If an investigation, okay, this one is for an investigation. If you're under investigation for something that would be a felony or misdemeanor with a forgery and all that stuff, all those, yes. So 14G2 is if you're under investigation for something that would be a yes answer. So again, who is the investigation initiated by? SRO, foreign, what jurisdiction, like city, state, SEC, whatever. When you got the notice, describe the nature of the investigation. Is it pending or not? If it's pending, then skip this. But if it's not, fill out what happened, explain, close without further action, close, initiated, other, and your comment. If it's a judgment or lien, this is the most common one. This is the one most people have to do. How much is a lien for? Who is it with? What is it, civil or tax lien? Like a civil is for like if you had a court case, taxes like if you owe bills, and they start putting shit on your house and stuff like that. Debt filed with the court, when you first learned about it, if you don't know exact explanation, was it federal, state? Most of them be state courts, right? Unless it's a real IRS lien. The docket, everything. Is it outstanding? Yes. If it's no, boom. If it's no, you can go right and just explain. If it is still outstanding, what the date is, and put it why it's still, and if it's resolved, if it's not resolved, whatever. Regulatory action. This is going to end up the U6 stuff. Okay. Okay. So this is for if the regulatory SEC, FINRA, a court came after you for regulatory violations. Again, where was it? Who came after you? What did they do to you? Monetary. If it's something other than these things, I don't know what it is. Death, castration, whatever it is. The day it started, the docket case number, who you worked for at the time, what was the product, your explanation, pending, on appeal, final. It's all the same thing. This is continued. If it's pending, if you're appealing it, boom, give the information on the appeal. If it's final, boom, tell them what happened. What were the sanctions? Were you barred? Bar temporary, civil, permanent, censure, disgorgement. Censure is like, hey, you shouldn't do that. Bar, temporary, suspension, stuff like that. Keep going. When the suspension started, when it ended. The details. How long, when it started, when it ended. Same stuff. Duration, when it started, when it ended. Literally the same shit over and over and over again. Boom. Okay. Now here's the interesting part. Sometimes if you have a license and you get suspended, they'll say, you know what? Part of the sanction is you have to get requalified. So it means you have to either go to training or requalification by exam. They may make you take the exam over again. Like we had a person, I think he got suspended and they took his 24 away. He had to retake the 24. He was a good guy. He just made a stupid mistake. Like he forgot. So we kept him. Okay. Same thing. Requalification by exam. Sometimes they just make you do continuing ed. So if they take away your license, they could say you need to requalify or take like continuing ed, like 12 hours or 5 hours of continuing ed. If it's a sanction, civil or administrative, monetary penalty other than fines. I don't know what that could be, but I guess maybe disgorgement. I don't know. Restitution, maybe. Same thing. If you have a payment plan, is it current? Date paid. If not, when did you waive any of the penalty? All this stuff is similar stuff. Again, this stuff is probably most of you not going to have. You'll probably have a lawyer do this for you. Okay. Now, if you're fired, okay, so if you're let go, the firm, discharge, this is all like if you were fired or permitted to resign while you're under investigation. Okay, permitted to resign, voluntary, or discharged while you're under investigation as part of it, what the product you screwed up on, your explanation. And that is the end of it, okay? So that's the end of the U4. Again, you're going to get it. You're going to either get it printed or they're going to give you access to sections you fill out. Most of the time now, I think they're all where you'll fill out a form at work when you start applying. They'll use that stuff, fill in as much as they can, and then they'll send it to you for edits. Like, is this right? And then you just go over every line, make sure it's all right. Make sure the name matches your identification, whether it's a license or a passport or whatever. Because when you go to take the licenses, again, they'll kick your ass out. They'll not let you take the test. I know it sounds right, but I had one of my students got sent away because their license expired the day before. Now you think, oh, that's cold, but it's not a valid license because it expired the day before. And here's a little thing. Once you pass the 7 or whatever, 6, 7, 79, 57, once you pass that, mark in your calendar to check your broker check or your FinPro account, really your FinPro account now, every year. I do think now you can update stuff in FinPro. It doesn't count as a U4, but you can update stuff in FinPro. So I would check your FinPro account every single year. Make it, just boom, set it. Because Knight Securities, maybe about 15, 20 years ago, maybe 20 years ago, they had a lot of people in Series 24s. And they just canceled them. And they decided, you know what? You're not acting in the capacity. We're not going to carry it. They didn't tell them. So when they went to another firm, maybe they did this on purpose. They went to another firm and they found out 1,500 people didn't have their 24. They all had to retake the exam because Knight didn't carry it and didn't tell them. If they knew, they would have said, wait, I need to keep it. And that's what FINRA allows now, the permissive registration. I'll say it again. Permissive registration allows you to keep those licenses. You can even say, listen, we'll take it out of your pay, but there's no reason not to have these things on. Okay, I hope that helped a little bit. This will help for the 24. This will really help you when you're filling it out, I think. I hope I didn't talk too fast. I was going fast through some of the stuff because I was just trying to get through the same drone. The middle part is where people have the most trouble. The DRPs, again, the DRPs are, that's a very rare instance. It happens. People have them. You can see on broker check when people have them. It's not the end of the world. Shit happens, right? Shit happens bad. Shit happens all the time. Most of the DRPs will be about the liens or the judgments. That's just because some creditors are just bastards, right? I hope that helps a little bit. I hope I didn't piss you off or ramble too much. Anyway, please check me out. If you're taking your licensing exams, I'm here to help you. Ken Finnen at Capital Advantage Tutoring. I'm here every Tuesday and Thursday night on YouTube, live Q&A. I was the first one to do it, and I'll be the last one to do it.